because she was not on a mental health caseload.
Right.
And so I know probation, they were supposed to go and give more information regarding that, and they sent an email to the court.
And so I'm going to take, good morning, or good afternoon, I can't do afternoon. Are you Almeida Miles? And so we reset Miss Miles' case for sentencing. This is 24 DCCR 2330, and Miss Miles is currently on probation. And a motion to revoke that probation was filed, and we were here, it looks like February 24th, and Ms. Miles entered pleas of true to counts 1 through 4 in that motion. The underlying offense is tampering or fabricating physical evidence with intent to appear, a 3rd-degree felony. And we reset, it was unagreed, and we had probation. Ms. Joseph is here with probation, find out some information with regard to whatever, I guess you could find out with regard to any type of mental health services or information. And it looks like she has not received any outpatient services with Spinal Tap, that they referred her to the outpatient clinic, but you did not see where she'd ever actually had an appointment. Is that correct, Ms. Joseph?
Yes, that's from the mental health staff with Spindle Top. They said that she never showed up.
And so it does look like if I were to continue Miss Miles on probation, that Miss Joseph spoke with a Dominique Mayfield who supervises the mental health initiative caseload, and that she advised that she would make the Tacoma referral, and that Miss Miles could receive treatment that way. Is that correct?
Yes, ma'am. But everything is contingent on this.
For sure. Yeah.
We could make services available, but if she doesn't follow through.
Totally agree. So timeline on, so part of the problem is that we sent Miss Miles to the ISF program, and that didn't work out. But the argument was that potentially it's because there were some mental health issues that had not, that's the argument. I see Miss Joseph is a little leery about that by her facial expressions. So I guess Mr. Smith, what is any thoughts?
Well, we tried to send her to ISF and she did not complete that program.
So Miss Miles, the last thing I want to do is not address something that needs to be addressed if there's some mental health issues. But I also don't want to be played and use that as a reason for me to continue on probation when that's really not why you violated or couldn't get through ISF. Does that make sense? Ms. Holmes?
I would be requesting that the court give her a chance to receive the mental health services. My apologies.
Okay. Of all times for it to happen.
Sorry about that. But I would like to see if she could receive the services. It looks like the history with her being on probation and does have a lot to do with how she handles situations, attitude, things like that, which I think.
The attitude and mental health are two different things, and that's where I am. That's my issue here, is this just a bad attitude problem, or is there really a serious issue that needs to be addressed? From the ISF documents, it looks pretty much like an attitude problem and not a mental health problem. Ms. Joseph, anything to add?
I don't deny that Miss Miles has mental health issues, but I don't subscribe to the fact that the behavioral issues at the intermediate sanctions facility, coupled with the disciplinary infractions at the county correctional facility, constitute mental health issues. However, should the court elect to continue Ms. Miles on probation, that the full plan is, and everything is already in her conditions of probation, she will be transferred to a mental health caseload where that officer can get the Tacoma referral. And if everything goes well, she'll be supervised on that caseload for a year. Then she'll come back to my caseload where she'll be supervised again for a year and to assess her progress before we transfer her to a regular felony case.
All right, so here's what I'm gonna do, Ms. Miles. And it probably could potentially be easier for you if I didn't do this, but here's what I'm gonna do. You're gonna have one opportunity at this, all right? And I want to make that very clear because Ms. Holmes is listening to me, Mr. Smith and Ms. Joseph knows that when I say this is your opportunity, this is it. If you don't take advantage of what I'm about to do, there is no ISF, there's no special needs safety, there's none of that. I don't want anybody coming back and asking me for any of that. It'll be a revocation and it'll just depend on what I decide to do based on the information that I have at that time, how long you go to prison. But you'll probably be going. Do you understand? So I'm gonna give you, they're gonna give you all the help you need. It's up to you to take advantage of it, just like Ms. Joseph said. So I'm going to find that you entered your plea on that motion to revoke freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I am going to continue you on probation. I'm going to order everything that Ms. Joseph just said. You will be on the specialized mental health caseload. You will get a referral to the Tacoma program. They will explain all of that to you, and you will be required to go to every meeting, follow through with any medication. All of those are now court orders. So whether you think you need the class, the meeting, the counseling, the medication, at this point, I'm ordering you to do whatever they say is best for you. You will be on zero tolerance. So what that means is that there's no, I just missed a meeting or I just missed something, give me another chance. This is your chance. If you mess up, you'll be right back in here, even just with one mess up. Does that make sense? All right. Anything else, Ms. Joseph, that you think would be appropriate for me to order?
I did want to clarify that upon her completion of the MHI caseload, she'll come back to
Yes.
Okay.
Then you'll go from the mental health caseload to the high medium caseload. That way you're not going from one super intensive to just kind of once a month. You're going to have a structured kind of step down process so that everybody can make sure that you're doing and everything you're supposed to, and that you're in a place where you're able to do that. Or if you need any further help, they'll get you that as well. All right. The disrespect and all of that, there's nothing that I can tell from any of the reports that I have that would show that there's some reason, mental health wise, for you to act the way you're acting at some points. Right. So that's not making you do some of those things. So I want you to be respectful to wherever you're going, the probation department, Spindle Top, wherever it is. You have to treat everyone with respect along that way, that path. Okay. I'm going to hand you the trial court certification. This shows this wasn't an agreement. There are some rights to appeal, but you can talk to Ms. Holmes about that. If y'all will sign that and give her the bottom copies.
Okay.
And I hope you take advantage of this opportunity. Okay. Good luck to you, ma'am. There he goes. All right, so you're Justin Joseph,
Yes, sir.
and Mr. Joseph has two cases on probation in each of those cases with motion to revoke filed. We've got cause number 20-35476. The underlying offense is possession of a controlled substance. And then we've got 20-35818. Underlying offense is evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, I visited actually with Mr. Nichols and my client. I think we were here previously. We had a bond hearing a few weeks ago.
Mhm.
At this time, we're at an impasse agreement wise, so this is what I think we have a hearing on this for us.
Do you want to go ahead and go through that motion and get
Yeah.
pleas of true or not true today then?
So,
Mr. Joseph, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
yes, y'all.
All right, thank you. You can put your hand down. And will he waive the formal reading of the motion in each case?
He does.
So I'm going to go back through. Yeah, that'd be good, probably. And I could probably do it on two. Actually, I need to. I'm gonna print it, this one also, just because it's easier. All right, ready? All right, and so, Mr. Joseph, in cause number 20-35476, I have a motion to revoke your community supervision. Shows that you were placed on probation July 11th of 2022 for the offense of possession of a controlled substance, a second-degree felony, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
And then in cause number 20-35818, I have a motion to revoke your community supervision. This shows that you were placed on probation that same day, July 11th of 2022, for the offense of evading arrest or detention with the use of a vehicle, a third-degree felony. And that was also a 10-year term in prison that was probated for 10 years. Is that also correct?
Yes, Your Honor.
Each of these motions allege that you violated your probation. Count one in each case alleges that you failed to submit to alcohol and or drug screening on November 4th, December 1st, and December 12th of 2025, and then January 2nd and January 12th of 2026. And is that true or not true?
True.
Count two in each case alleges that you failed to submit a valid urine specimen for alcohol and or drugs, in that on January 14th of 2026, you attempted to provide toilet water from the urinal instead of your urine. Is that true or not true?
Not true.
And then count three in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 3 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those because they're both actually true?
Sure.
And do we have here to, we have probation here, but you wouldn't have been the one that did that testing. Is that correct?
No, ma'am, that was Officer Menard.
Okay, so what I'm going to do is find in each of your cases that you entered your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probations. However, I'm going to reset your case for sentencing. We can get an updated pre-sentence report. Mr. Nichols can have that officer here to testify with regard to count 2. And then we will go forward at that time with any sentencing. And there is no agreement. This is unagreed, correct?
Yes, ma'am.
Okay, we'll see you back at sentencing.
What do you guys think?
You're Caleb Jubert,
Yes, no.
and Mr. Jubert was previously in court, entered pleas of guilty in cause number 25 DCCR 1130 to unauthorized use of a vehicle, a state jail felony, and in cause number 25 DCCR 1131 to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review it?
Yeah, Judge.
I have, Judge.
Are there any additions or corrections?
No, Judge, not at this time.
Only that the state concurs with the recommendation of ISF cognitive judge.
All right, thank you, Ms. Malfino. All right, Mr. Jubert, I am, So, Mr. Jubert, I know you know this already because everybody out there knows that I get the jail reports, right?
Yes, ma'am.
So there was an issue pretty recently. You haven't had a lot, but just recently you had earlier this month, one about a mattress, right?
Yes, ma'am.
And you weren't very respectful about what you said to that officer when they said for you to give up one of those mattresses, were you?
Yes, ma'am.
So it's the same thing that I say to everybody. If you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation. Does that make sense?
Yes, ma'am.
So part of this agreement or part of the recommendations in this agreement is for me to go along with giving you probation, but send you to the ISF program, the cognitive track, which is a program to help you make better decisions. But I want you to understand if I follow along with this agreement and you get any more incident reports, either here or at ISF, it's going to be a violation of your probation and you never get out of jail before you violate it. And I know you've been out there long enough to know that I've done that already, right?
Yes, ma'am.
Okay. So then what I'm going to do, Mr. Jubert, is give you this opportunity. I'm going to find in each of your cases that you entered those pleas freely and voluntarily. In cause number 25, DCCR 1130, find sufficient evidence to find you guilty, but I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. And then in cause number 25, DCCR 1131, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings for 5 years. You're ordered to pay a $300 fine in that case and to follow all of the rules and conditions of probation. One of those conditions in each case is again that you enter and successfully complete the cognitive track of the ISF program. Also, there's going to be you're going to have a couple of assessments done just to see what all probation needs to offer you so that you can be successful. There's going to be a mental health evaluation, substance abuse evaluation, and if there's anything in those evaluations that say that you need some further treatment for whatever it is, then it is going to be your responsibility to do that and part of your probation. Do you understand?
Yes, ma'am.
You're going to get all the tools that you need to be successful. You're young, you don't have felony conviction on your record right now. If you successfully complete these probations, you will never have a felony conviction. This is a great opportunity. But the other side of that is if you violate any condition and you don't take advantage of the tools that are going to be given to you to be more successful, you're going to be right back in here in court. You're going to be looking at up to 2 years in a state jail prison in one case and between 2 years and up to 10 years in prison on the other. You understand?
Yes, ma'am.
Again, I want to make sure I reiterate how important it is not to get in trouble in jail while you're waiting on ISF and not to get in trouble while you're at ISF. If other young men are out there acting up, you need to say, look, I want to see the light of day again. Y'all go do what you're going to do. And I'm going to today sit on your bunk when you're supposed to sit on your bunk. Don't sit on it when you're not supposed to. Have whatever you're supposed to have. Don't have extras. Just follow the rules. And if you're called out for not following a rule, don't get mad at the person that's calling you out for not following the rule, right? You're the one that's not following it. So don't get mad at them. Okay. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed. So you have waived your right to appeal. Good luck to you, sir. I hope you do well.
Thank you.
Let's see, John Lamel. Good afternoon, sir. You Andre Williams the second. And Mr. Williams' cases are set for trial to begin with jury selection next Monday in cause number 24 DCCR 2286 charged with murder and cause number 24 DCCR 1539 charged with tampering or fabricating physical evidence with intent to impair. What is the announcement?
Your Honor, I'm asking for more time. Let me try and articulate to the court why. I am still trying to obtain Mr. Williams' records, his Social Security disability benefits that he received from 2009 to 2022 when he was a child. His mom or someone tried to reapply in 2022 and they were denied. I know the court's aware of this and the court's been very patient. And Mr. Williams signed a release a long time ago and it was submitted to Social Security, and I don't know what became of it. It was never processed. They don't have a record of it. I've been told that it was probably ignored because at the time, Mr. Williams had no open case and had no claims. We're on the right track now. I'm asking for 30 days. I know the case is Mr. Williams was indicted 18 months ago. And I know the case is getting on, but I believe this information would be relevant for mitigating purposes. And I'd ask the court to view my request in that light.
Mr. Nichols?
State's ready for trial, Your Honor.
I just feel like I've given so much time for this, and obviously, Mr. Williams is just sitting in our jail. We've got a family also of a victim that's waiting on this trial. And, I think, if something is potentially important, I don't disagree that it could be important. I think there might be, another way that you would have to get that information in at trial. This time I'm going to deny that motion for continuance and number the trial. There's a couple others. I'm not sure that it will be the number one case, but I will number them as soon as docket's over today and you'll know.
And Your Honor, if we were in a situation where Mr. Vasquez wanted to put on some testimony about whatever condition Mr. Williams had that he was receiving disability for, I wouldn't strenuously object if it came from a family member with knowledge of that situation. So we may not
Okay.
need the actual records to get that information in.
Okay, that's what I appreciate that, Mr. Nichols.
Thank you.
And so again, I'll number the case. Is there any change with regard to any negotiations or?
No, Your Honor, Mr.
reject-
Vasquez, I'm sorry to cut you.
Go ahead.
Mr. Vasquez had approached me the last few weeks, asking if I would come down from 40 years. I have not, and that is the offer, and it's being rejected at this time.
All right, and Mr. Williams, you still want to go forward, is that correct, and not accept the 40? I'm sorry? No, you're not getting a new lawyer, you're gonna get a trial probably next week, so I just want to make sure you don't want you don't want to accept any plea agreement, is that correct?
You taking them forward?
Okay, so your case will get numbered. It's likely to be the first case on the docket. I do want to remind you, if I haven't told you already, Mr. Williams, that I see, your attorney sees, the district attorney sees, and any jury potentially will see all of the incident reports from the jail. So you should keep that in mind on the things that are going on out at the jail, because I have a 15-page set of documents here from incident reports for the last year that you've been in our jail. So keep that in mind, and we'll see you Monday. All right,
Yeah.
I'll number it after docket.
Thank you, Judge.
Not quite as outnumbered. All right, are you Maribel Reichel? Yes, ma'am. And will your client waive the formal reading of the indictment?
She does, yeah.
Yeah, okay, Ms. Reichel, in clause number 25, DCCR 0664, you're charged with the state jail felony offense of unauthorized use of a vehicle from April 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablets of documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Reichel is not competent?
No, Judge.
Okay, Ms. Falco, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. As part of this plea agreement, I will sign the dismissal and cause number 26 DCCR 0581. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible.
This may be the most legally significant moment in the hearing, because the court is now balancing the defendant's right to prepare a defense against the victim family's right to finally see this case go to trial. Andre Williams is facing a murder charge along with tampering with evidence, and his attorney is asking for more time to obtain Social Security disability records that could potentially be used for mitigation purposes. But the judge makes it clear this case has already been delayed for a long time, and the victim's family has also been waiting for answers. Legally, continuance requests like this can become a major issue, because judges must decide whether additional evidence is truly necessary or simply delaying proceedings further. Then the tension escalates even more when the prosecution confirms a 40-year plea offer was rejected. Here's the question. If you were facing a murder trial and decades in prison, would you risk trial or take the plea deal? Moments later, the judge pushes the case toward trial preparation.
You're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. You can go back with the bailiff. And then we've got Angela Reyes. Let's let Mr. Coleman grab his file real quick.
Thank you.
Good afternoon, sir. Are you Calvin Hawkins Jr.?
Yes.
And this is 24 DCCR 1160, and Mr. Hawkins is charged with unlawful possession of a firearm by a felon from January of 2024. And what is the announcement?
Right now, Your Honor, we were hired on this matter a little more than a month ago. We just have, we haven't received the safe kit.
Okay.
They were supposed to be mailed to us. We just have to see.
Okay.
Just by email, I informed defense counsel of the process, or at least the to contact our trial division to make arrangements
Sure.
to get the digital media. I've provided access through the discovery portal to the documentary evidence, but I don't know if they've made some arrangements with our trial division.
Usually it's picked up, but what I'll do, Ms. Bosley, is I'll just do a normal reset. It's about 30 days. And you may want to just go run upstairs and just see if it might be there and ready since you've come in. And if not, make double sure that they're either mailing it or that you might need to come back and get it, or provide them with whatever they need to do that. And that way you'll have some time to get that. And then I'm sure visit with you about whatever information and discovery she receives. And we'll see if we can get an announcement the next court date. All right. Thank you, ma'am. Ms. Holmes, you've got Almeda Miles. It's sentencing.
Yes, sir.
Almeda Miles.
I'm sorry, the confusion was that Mr. Kelly wrote down what was essentially a today only offer on the rejection. And it didn't necessarily reflect what the actual offer was if you didn't take it today, Judge.
Okay. All right, sir. Again, you're Dondre Blewett.
Yes, ma'am.
And Mr. Blewett, in clause number 26, DCCR 0362, you're charged with the second degree felony offense of aggravated assault with a deadly weapon from February 1st of 2026. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tab a plea bargain rejection that shows that the district attorney's office has offered a 10-year term in prison. You have every right to reject that. It sounds like there was another offer that was put out there today if you wanted to enter a plea today. Regardless, I want to make sure you understand any offer after today could potentially be off the table in your case. Once it's on the trial docket, will be expected to go to trial. And is that what you want to do?
That's fine.
All right, and then we also have cause number 22-41150, which is that motion to revoke your probation on the evading arrest or detention with the use of a vehicle. Obviously, depending on, we'll go forward with the underlying new offense first, and then depending on what happens in that case, because it's more serious, I will carry the motion along with it, and then we'll take care of it later. It looks like probably was it just a concurrent offer?
Yes, ma'am.
So if you wanted to enter pleas of true in that, the state made an offer to run that concurrently with the 10-year sentence. You also have every right to reject that. And then that eventually will be left up to the court, your MTRP, not a jury. Does that make sense?
That's me.
But I just want to make sure on that new case, you want to reject the offer and go forward with the trial. Okay, we'll get it set for trial, and Mr. Kelly will begin preparation.
Thank you.
You can go back with the bailiff.
That's just what I do.
Need some time. I can reset this till next week.
Please, because when I spoke with the victim in this case, she wanted to be here at this hearing and testify to the court about the extent of her injuries, the extent of the damage to her vehicle. And I
Listen.
told her that it was set for May 12th. In addition, I've given Mr. Macon notice of a prior a paramour of this defendant who also would like to be here and give testimony as to the nature of their relationship with this.
I'm gonna reset it till it'll be Tuesday. And do we have an 11 o'clock on Tuesday already? Let's do it. Since there's gonna be a couple of witnesses.
Next week, we have the next two.
Okay, we'll have to we'll figure out a time next Tuesday.
Yes, ma'am. Thank you.
Because we've already got something at 11, so we'll try to get something in as long as it is, bring the witnesses, but, okay. Good afternoon, sir. Are you, Hayden
Yes, ma'am.
Burkhalter?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
Oh, he does, yes.
Sorry.
I'm sorry.
That's okay. And so, Mr. Burkhalter, in cause number 26, DCCR 0324, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from January 22nd of 2026. And how do you plead to that charge?
Guilty.
I'm sorry.
Guilty, ma'am.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, sir.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, sir.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing which program?
I believe it needs to be cognitive.
The cognitive track of the ISF program. Is that your understanding?
Yes, sir.
And I'm writing cognitive in just so
Okay.
that's with everybody's permission.
Sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
Allegation, Judge.
It's admitted. Is there any evidence that Mr. Burkhalter is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. All right, you're going to get some paperwork today to take back with you. Have that filled out so that when probation comes to visit with you, it'll make it go a lot more smoothly. All right, you can go back with the bailiff.
The court had rejected that at one point in time, but
Well, I was just about to ask you because I have a note that I rejected it,
Right.
right?
Right, it was, you rejected.
It was a cap of 16 months. He denied it. And then there was also the criminal history.
Right.
And so I think I reset it for you guys to visit about any alternative negotiations thing. Because I wrote on here that I already rejected it.
Okay, I think we were questioning about what the court would find acceptable. I think was trying to get it worked out. I think it was initially a cap.
Well, it was a cap of 16
16
months in the state jail. And one of my notations was that he's already had 1, 2, 3, 4, 5 state jail sentences.
Okay,
And this should be a 2 to 10 case. And I
Okay.
don't think a state jail felony would be in my opinion, that doesn't make any sense when it's the same type of offenses for him to still be in the state jail range. It's time for some more
Okay.
consequences.
And he did receive the benefit of county jail time on most of those, Judge. So I think our concern was if we went on the somewhat, not bare bottom lower end, but somewhat lower quarter or so of that punishment range, would the court be willing to accept that TDC?
Yeah, I mean, do something different and it'll probably be okay, but I was not okay with just 16 months. Because some of them show 2 year state jail, 2 year state jail in 2023, two cases.
Yes, I was referring to the ones previous
Okay,
in 21.
were those,
Those were state jail convictions, but he received the benefit of county jail time, which supports your
right, so we're
position.
doing the same thing and
Yes.
things got to get worse if you're going to keep doing the same thing. So if y'all want to visit today,
Yes.
get that
yes.
paperwork done because everything was deleted because I rejected it. So you'll need to do new paperwork
Okay.
because it would be also TDC paperwork as
Okay.
well.
So I have talked to Ms. Garcia, so we've talked. So I
Okay.
think if we just hold it for a second.
I'll
we'll
hold
get
it.
done.
All right, sounds good. Well, I'll keep. Yeah.
Just.
What about, good afternoon, sir. Are you John Lamel?
Yes, sir. Oh, no, ma'am, I'm Romeo Johnson.
Okay.
I'm sorry.
Yeah, it's wrong.
I'm sorry.
Good afternoon, sir. Are you John Lamel?
Yes, ma'am.
Okay, we got the right one. And Mr. Lamel has a motion to revoke probation and cause number 21-38857 on probation for the state jail felony offensive theft. And what is the announcement?
Judge, this is one that I was recently appointed to Mr. Mail after I got it from, he was dealing with Mr. Cobb and Mr. Adams.
Yes.
And I just got it. I haven't even talked to the state. Well, I think we may have a resolution on this that can take care of this as well as the misdemeanor stuff here.
Okay.
Well,
By the end of this courtroom session, the judge handled everything from probation violations and mental health concerns to violent felony charges, rejected plea agreements, and major sentencing decisions. Some defendants were given structured opportunity for rehabilitation through probation programs, treatment referrals, and intensive supervision, while others moved one step closer toward trial and the possibility of lengthy prison sentences. One of the strongest themes throughout this hearing was personal accountability. Again and again, the judge emphasized that probation is not simply freedom. It is a final opportunity that comes with strict conditions and serious consequences for failure. The courtroom also highlighted how mental health, substance abuse, jail behavior, and criminal history can all directly influence judicial decisions during sentencing and probation hearings.
Okay.
well, I'm asking for about maybe a week or two, just so I can get that finalized and then we can get it done.
I agree, Judge. We're very close.
Okay.
Not close to reset.
And I know it looks like it's been around, but I do know that you've gone through some attorneys. Mr. Lewis will take care of that. So we'll just do maybe a couple of weeks at the most. That way you can get everything
Right.
taken care of and we'll get it. That's fine. All right, we'll get it taken care of then. You can go back with the bailiff, but just do a short reset.